Good afternoon, everyone. Thank you for joining us for today's webinar, The Importance of Enhancing Procedural Justice in Interactions with Juveniles. My name is Carissa Rano, and I'm with OJJDP's National Training and Technical Assistance Center. As your technical host, I would take up a couple minutes to discuss a few features of the Adobe webinar platform and provide a few housekeeping announcements. For those wishing to download a copy of the PowerPoint slides and other important documents, you may do so by locating the Handouts pod directly above the chat area. Click on the name of the file and then click the download button. At the end of today's webinar, there will be a Q&A session where the presenters will address some of the questions posed during the presentation. Please type your questions into the chat box as they arrive. For those of you participating in today's webinar as a group, please take a couple of minutes and help us count. Go to the chat window and type the total number of additional people in the room with you today. If you are viewing alone, there is no need to type anything into the chat pod at this time. At the conclusion of today's webinar, you'll be provided with a link to a brief survey about today's presentation. The feedback you provide is useful for assistance in future planning and training. Following today's webinar, attendees will also be sent a certificate of attendance. The certificate is sent approximately 1 hour following the conclusion of the event and is sent via Adobe Connect thank you email. Please keep an eye out for your email for the certificate. Finally, this event will be archived in approximately 3 weeks on OJDP's online university at www.ojdpou.org, where you can also view past webinars. Thank you again for joining us today. I will now turn it over to Megan, our moderator for today's webinar.
Hi, everybody. My name is Megan Quattlebaum, and I'm the Program Director of the Justice Collaboratory at Yale Law School. Before we start, I'm just going to introduce our two presenters. I'm going to do very brief introductions, although they merit much longer ones. You can find out more about them on the Yale Law School website. First off, Tracy Mears is the Walton Hale Hamilton Professor of Law at Yale Law School. Most recent accomplishment was that she was named as a member of President Obama's Task Force on 21st Century Policing. Tom Tyler is the Macklin Fleming Professor of Law and Professor of Psychology at Yale Law School. And with Tracy, they are both members of the National Academies of Sciences Committee on Proactive Policing. So both of them have written extensively on the topic of procedural justice, which is our subject today, and we look forward to hearing more from them. So with that, I will turn it over to Tracy Mears.
Good afternoon, everyone. Hope you're out there staying cool. Tom and I are really happy to be here to join you today to talk about procedural justice and how these principles can help those in the criminal justice system better interact with juveniles in the system. So we think the starting point is to point out that most of our research focuses on the quality of interactions that young people have with legal authorities in the criminal justice system. This is crucial, and so the question is, why is it so important? The research shows very clearly that it's the quality of the interactions that young people have with police officers, judges, prosecutors, their own lawyers, that impacts how they view the legitimacy of the system. And when we say legitimate, we are talking about a particular aspect of legitimacy. We're not talking about philosophical notions of legitimacy, but instead we're talking about empirical investigations, positive investigations of how people understand legitimacy. So when we use that term, we are referring to the idea that people believe that an actor in the system is legitimate or the system itself is legitimate when a person believes that the authority enforcing the law has the right to do so. Legitimacy is critical because the research shows that the perceptions that the public has of legitimacy has a lot to do with how people think about their decisions to obey the law, and also actually to cooperate with authorities, engage with them. The research is very clear that in fact perceptions of legitimacy are more important than ideas such as deterrence, immediate deterrence, which assume that people obey the law only because they fear the consequences of failing to do so. Okay.
So the background for the concern about contact between juveniles and the legal system is that the rate of contact that adolescents have with the police and courts is high. In fact, for most people, they're very likely to have contact with the police or courts as adolescents and more likely than as adults. So in general, just to give you a sense for the numbers, in 2011, juveniles were involved in 11% of all arrests in the United States. Now, of course, that underestimates the rate of youth police contact, and we know actually that it's much higher. What's really important from our perspective is that we know from research that the disposition of these initial contacts has a very strong influence on attitudes towards the law, the police, and the courts. When we talk about legal socialization, the really central point is that these early contacts shape the orientation that juveniles have towards the law, towards the police, towards the courts, and of course, in so doing, shapes their likelihood of adult criminal conduct. So what we'd like to use as our metaphor for talking about contacts between juveniles and the police and the courts is the idea of teachable moments. You may remember that President Obama used the term teachable moments in one of his discussions about the police. And it's a really good way to think about every interaction that a young person has with a police officer or a judge. That is, every time they have an experience, they learn about the law. And what they learn about the law, about the police, about the courts, especially important during this period in their life, shapes what they do later, both their adolescent and their adult criminal behavior.
So then the question is, what exactly shapes that impact? What we've found is that there is a relationship between this idea of legitimacy that we were just talking about and the notion of procedural justice, which itself is an understanding of how people understand their relationships with legal authorities. The key finding here, going back to what I was saying at the beginning, is that how juveniles, actually anyone, but we're talking about juveniles, how they understand the fairness of how legal authorities manage their problems and their interactions has much more influence on the particular outcome of the case. Now, one way of understanding that is a very simple one, which is one idea would be that people would have an understanding of a legal authority based on whether the outcome of a particular disposition favored them or not. The research doesn't show that that is as important as the extent to which legal authorities handle the disposition in a fair way. And we know that this understanding that juveniles and other members of the public have has important outcomes. First, whether people tend to accept and continue over the long term to abide by decisions of legal authorities, how they evaluate legal authorities in every aspect of the system, and the extent to which they're involved in later criminal offending. So we think that since the key role of those in the criminal justice system is to help those who go through the system feel that their case was handled through fair procedures, that is the focus of our webinar today. We think then that this particular slide should be crystal clear, but just to drive it home, There are many benefits for those who are involved in the system, obviously, apart from its benefits for the youth, which I think we think are also self-evident. First, it leads to positive views about the legal system actually for everyone involved. It encourages youth and others to comply with the law in the future. And last, and perhaps much more, probably the most important, it promotes the health and well-being of young people.
Let me just give you an example to give you a sense for the strength of the findings that we're talking about. I'm going to draw from a study that was done in 2 cities, Oakland and Los Angeles. This study is helpful because it looks at people who dealt with legal authorities for 2 different reasons. One is to seek help, and the other because they were being stopped, so they're being regulated in some way. And the second is these communities were chosen because they're multi-ethnic. So the study included white, Hispanic, and African American respondents, and the study dealt with both the police and the courts. Well, again, as Tracy said, let's think about how would somebody react to an experience that they might have with a police officer or with a judge. One way you could look at it is they might simply look at the disposition and say, did I win? So think about your own situation. You might say, did I get a ticket or did I not get a ticket? You go to court, did I get a judgment or did I have to end up paying something? That's just straight out economics. Did I win? A more nuanced way of thinking about outcomes is, did I get what I deserve? So people have a sense for what's an appropriate or lawful outcome. Did I get that outcome, the outcome that I deserved? Now, as we've been saying, the key research finding is a separate issue. That is, was my case handled in fair ways, is emerging as really important, and you can see how it's distinct. It has nothing directly to do with the outcome, but it's about the way that the authority managed the interaction. How did they handle the case? So let's just look at some results. An obvious question that we can immediately ask is, why do people accept court decisions or police decisions? Here we're going to just use the example of courts, but the results are the same for the police. This shows 3 different columns for decision acceptance. Each one shows the weight that a different factor has in determining acceptance. So what do we mean by acceptance? What we mean is you walk out of court or you walk away from a police officer saying, I'll go along with what they said, I'm going to do what they said, I'm not angry, I'm not going to appeal, I'm not going to try to get around it, I'm going to do it. So it's basically acceptance and deference to the authority that you've dealt with. Does it help if you get a favorable outcome? Yes. And you can see from the purple column that it has a little bit of an effect. You're more likely to accept an outcome if it's in your favor. Similarly, you're slightly more likely to accept an outcome if that outcome is fair. But the really dominant reaction is to the fairness or unfairness of the court procedure. You can see that overwhelmingly whether people accept a decision depends upon whether they think that the court procedure was fair, how they feel about the judge. Overwhelmingly a response to whether the procedure was fair or not fair. Now, as I said, we could do police, get exactly the same results if we do the police. The second important point is we talked about the multicultural or multi-ethnic nature of this study. One of the things that we're always talking about is whether white and minority individuals have a different way of thinking about their relationship to the police or the courts. As this shows, the answer really is no. Depending on ethnicity, you could expect something different, but we really don't see it. We see whether you're white, African American, or Hispanic, whether you accept the decisions that are made, predominantly a reaction to whether you think you did or didn't get fair procedure. This is a really important point when we think about moving forward and trying to deal with people of different races or ethnic backgrounds, that we can be confident that people in general react the same way to their dealings with the police and the courts. And again, this is an example of the courts, but the same findings would be true if we looked at police. And then finally, we know that there are two ways that people can deal with the police or the courts. One way is they can come to them and ask for help. So you can come to court and you can be coming with a problem and you're saying, I want the court to help me to resolve this problem. Or you can be required to come to court because you're a defendant in a case, you have to come in, you've broken a law. Same way with the police, you can go to the police for help, or you can deal with the police because they stop you because they feel you're committing a crime. Does it make any difference? Look at the results here. No difference at all. Irrespective of whether you're bringing your problem to court or whether you're required to come to court, the main reason that you do or don't accept what happens when you get to court is you don't think, or you do think, that you got a fair procedure. Not good or bad outcome, even fair or unfair outcome, but did the judge handle this situation through a fair procedure? Okay, so just to give you an example of the way people deal with the police and courts, we're using this Oakland and Los Angeles sample, but this is a sample of people of all ages. What we want to emphasize is that other studies that focus on juveniles find essentially the same thing, that juveniles are primarily focused on the fairness or unfairness of the procedures that they experience. Just to show you that this is true, we'll give one example of a study that was done in New York City with young people. This is an example of people who dealt not with the courts but with the police. And again, this is young men in New York City stopped by the police. So it's primarily police stops on the street or in cars. The primary issue was whether the police did or didn't treat the person fairly, and this study showed that there was a big impact of these experiences with the police on legitimacy and subsequent behavior. Just to give you an example of the importance of these experiences, those people who had experiences with the police that they felt were unfair were twice as likely to be engaged in criminal behavior. And I would emphasize that this is an effect that was found after the study controlled for other factors that predict criminal behavior. So basically, the impact of an experience with the police was strong enough to noticeably change the likelihood that the person thought the legal system was legitimate, thought the law was legitimate, and then was engaged in later criminal behavior.
So before we go and discuss how we actually understand the idea of procedural justice, I want to go back to a few things that Tom was just talking about. I know that we have a very varied group, that there are people who are police officers or work in policing agencies. Some people actually work in the juvenile court. Some folks work with young people directly, such as school resource officers. Some people are defense lawyers, so on and so forth. And so we might all have a different idea of what procedural justice means. So I think before I talk about the four factors that we focus on in the research, I just want to emphasize that when we say procedural justice, we're not actually talking about procedure the way that a lawyer would talk about it. This is not about constitutional criminal procedure or the rules that structure the way courts operate, or the specific operating procedures necessarily of a policing agency. But we use the term procedural justice actually to distinguish it from the ideas that Tom was talking about before in terms of outcomes. So if you look at the history of the research, the idea of procedural justice was brought up to distinguish it from an idea of distributive justice, which is, again, a focus on outcome, the ways in which people might think that outcomes are fair because you get something that you deserve, not something that you want necessarily, like not getting a ticket, but you get an outcome that seems fair to you vis-a-vis other people. The focus on procedural justice was meant to answer this question that came up in the early research, which showed that people were constantly focused on how they were treated even as they evaluated some particular outcome that they received. And that was perplexing to the researchers in the early 70s when this research came up. And then my colleague sitting here next to me, Tom Tyler, and a colleague of his, Alan Lind, wrote a book in 1988 called The
Social Psychology of Procedural Justice.
and clarified what was important about procedural justice and why it's important. So what I'm going to talk about right now is what is important about procedural justice, and I think we'll actually get to the why that matters to people as well. All right, so 4 issues are important. As you see them on the slide: voice neutrality, which we think of as a form of decision-making. I'll explain that a bit more. And then 2 factors relating to quality of treatment. So first, voice. What we mean here is that people want to have an opportunity to tell their side of the story in an interaction with a legal authority. And what's really interesting about this is that the research shows that this is important even in situations in which it's very clear to everyone, both the person making the decision and the person wanting to tell their side of the story, that it makes no difference to the outcome of the interaction. Now, it's important to know that when people are talking about voice too, it can go beyond the particular interaction that a person is having with an individual legal authority. So as you see here in the next slide, the implications are, the obvious one is if you're having an interaction with an officer, to the extent that it's possible and it makes sense, give the person an opportunity to state their case before a decision is made. But it's also the case that this idea of voice means that you want to give a person or groups of people opportunities to set agendas, have input. So a second implication, for example, is that there should be forums created that give people input in policy making. Okay. A second issue is usually referred to at a very general level as decision-making fairness. Here, we're focusing on one aspect of it, is neutrality. It's also true if you look at the way we're describing neutrality, is that it's a general, high-level. I don't want to call it catch-all, but it's a more abstract term. So the key here is after voice, what people are looking for are indicia that decisions are made fairly, based in facts, and not personal opinion, and are not biased. So what does that mean? It means that decisions should be neutral and they should be transparent. How do you go about that? It's important to explain what you're doing, even when it should be obvious or it seems obvious to you as a person in legal authority what's going on. It's especially important for judges to explain court procedures. Judges, I think, are sometimes, they're used to saying the same things over and over again, and so it might seem obvious to them what the rules are, but it's actually not obvious to the people who are participating in the procedure, especially young people. And last, explaining the basis upon which decisions are being made. In other words, you can't necessarily just state an outcome, even an outcome that favors someone, and expect them to think that it's fair. It's better to actually explain the
distinction here is between being fair and being seen to be fair. Often when we talk to groups of judges or police officers, they say, well, I am neutral, I am fair, I am following the rules. But what the point Tracy's making that's really important is that's different than being seen to be neutral by the people you're dealing with who don't necessarily have your legal background, they don't have your awareness of the rules. So it's not just making a fair decision, it's explaining to people so that they are aware that the decision that you're making is fair.
So if the first two aspects of procedural justice focus on components of fair decision making, the second two factors that really matter to people focus on how people are treated. So our third factor is treating people with dignity and respect. Often in some of the literature, this particular factor has been sort of blown up and considered almost coincident with procedural justice. You'll hear sometimes folks in policing agencies and police executives saying, well, all procedural justice is treating people politely, and you can, do whatever else you want to do. I think the first two factors make clear that that's not the case, but the other important part about this factor is even treating people politely is only one aspect of showing respect. In addition to treating people with dignity and respect, it's important to show concern for people's rights. So here we go on implications. We've already spoken to the courtesy and politeness aspect. It's critically important. The research shows that. But respect for rights is also critically important, and I think points up the fact that even when legal authorities act in ways that objectively can be considered polite, if while being polite they are also acting in ways that people interpret as denigrating rights that they have, then that will not be behavior that's considered procedurally just and therefore will not be considered legitimate in the ways that we describe it. And the last factor, we use, again, an abstract term, trust. If you're looking at the literature, specifically, we use the idea that the last factor is captured by the notion that people want to be able to expect to be treated benevolently by legal authorities in the future. There are lots of aspects to this. Some of the aspects are captured on this slide. That is, taking the time to listen to people, taking them seriously, trying to do what's right, acting in their interest. Going back to what Tom has said before, it's not so much that a legal authority does these things in a way that that authority thinks is the case. That is, I think about an interaction I'm having with my child. I will be convinced that I am taking my children's interests and their case as they're stating it to me seriously. But if they don't perceive that that is what I'm doing, then you're not actually capturing what this slide is trying to convey. Therefore, we say a little bit more in this slide about the implications. I will, for example, going back to my children, be convinced that I am taking what they're saying seriously while I am looking at my iPhone. Obviously, that's not going to work here. Second, acknowledging people's needs and concerns. Certainly, some of that is about an interaction, and so some of this pertains to how a legal authority is interacting with an individual. But understand, all of the aspects of procedural justice can also be understood at the agency level or higher levels. And so there are lots of other ways that agencies can acknowledge people's needs and concerns and indicate to them that they are taking their concerns seriously. Here, I think one of the most important things that agencies can do in terms of engendering trust can be to take steps to acknowledge problems and past wrongdoing, because we have very strong theoretical reasons to think that the work of another aspect of the National Initiative for Building Trust and Justice, the reconciliation piece, is directly implicated in this particular factor of procedural justice. Notice last that one way you can engender trust is to explain your decision. That is actually something that we've already talked about earlier in decision-making fairness. Sometimes in some other presentations on procedural justice that I've seen that aren't as deeply theoretical will actually collapse this last factor to this particular point. Explain your decision. Obviously, that is only one aspect. Can't be the only aspect of building a perception of trust-based motives, but it is an aspect of it.
So the key point here in terms of showing people that you're sincerely interested in them is that when a young person talks to you about their situation or explains their needs and concerns, that you show some awareness, you actually listened to them and thought about what they were saying. So the point Tracy's making about explaining is it's not just that you provide an explanation, but that the explanation shows some attention to what people have been telling you. It's not just, I know the rules and I decided to do this, but I heard you talk about this problem, or I heard you express this concern. Even if what you're saying to a person is, regretfully, I really can't do what you're asking, I don't have the power to do that, or it's against the rules, but I understand the concern that you're expressing to me.
So just to emphasize this last point is the research suggests and shows that interpersonal treatment is really important and much more important than a particular outcome that favors the person or the youth that a legal authority is dealing with, or even the distribution of those outcomes. People really care about being treated with respect and dignity and concern for their rights. They are looking for indicia that authorities care about them, their needs and concerns. They want to feel that they are being listened to and their views are considered. Basically, the bottom line is when you're dealing with a member of the public or a youth, in a particular youth, that person wants to believe that you, as a legal authority, believe that they count.
So why is this important? This is a discussion about how people want to be treated and what kind of treatment affects whether they walk out of an interaction with a police officer, walk out of an interaction with a judge with greater respect for the law, with more of an orientation to obey the law, which we know predicts that they're willing to follow the law, that they're willing to cooperate with the police, a whole bunch of behaviors that are important. We also know that as it stands now, the average impact of a contact with the police is to lower trust and confidence in legal institutions and increase the likelihood of criminal behavior. I mentioned the study in New York. Those who are treated unfairly are more likely to engage in future criminal conduct. If people are repeatedly stopped, they begin to see all of their interactions as unfair. So in other words, we know that on average, the contacts that people are having are not being experienced by them as being fair. And the consequence of this widespread experience of unfairness is, in fact, deteriorating trust in the police and courts, which, as we said, creates more law-breaking behavior in the future. On the other hand, we don't want to come to you with what we think is a pessimistic message, because we don't think pessimism is necessarily the right answer. If we change the nature of the contact that people have with the police, with the courts, with whatever person or institution they're dealing with, so that the people who have those contacts experience those contacts as being fair in the way that we've described, we also have evidence that you can build trust, and that so people can increasingly view the police, view judges as helpful, as reassuring, and as a consequence, you can be doing what you need to do to enforce the law, to make legal decisions, and at the same time building legitimacy and trust. Now, consistent with what we just said about the police, we know that the traditional justice system, for example, the court adjudication system, has trouble dealing with young people. And as I said, we know that the general effect of being involved with the police or the courts is to increase the likelihood of future criminal behavior. So one approach, diversionary programs, try to keep people out of contact with the system so that as much as possible we don't bring juveniles into contact with the police or contact with the courts. But as we said, an alternative is to try to reimagine those institutions along the lines of procedural justice so that contact doesn't have to be avoided, because the contact that people have is contact that's experienced by them as more fair. There are many, many alternatives that have developed in the arena of the courts. We list a set of them here. You've probably heard of many of them. Alternative dispute resolution, community courts, drug courts, problem-solving courts, restorative justice conferences. These are all alternatives that have developed because people have recognized that the general effect of traditional adjudication is negative. So the traditional adjudication effect is negative, the contact with police effect is negative in general today, although these approaches show that it doesn't have to be that way. And so why are these alternative approaches better? Fortunately, we actually have research on that, and we know that procedural justice is central to the appeal of many types of different courts, not traditional courts. Just to use an example, drug courts, we have studies of why it is that drug courts have better effects for young people, problem-solving courts, restorative justice conferences. They all have better effects because those people who are involved, in particular those juveniles who are involved, experience these procedures as fairer. So they are alternative approaches that have a better outcome because they're experienced as being fairer.
So we're going to wrap up now before we go to questions, but here are our big takeaway points for you. First, procedural justice is robust, and by that we mean there is a long research tradition with literally hundreds of studies showing that these factors, as we've described them, matter to people and are the key factors that members of the public, whether adults or kids, actually rely upon in making determinations about the fairness of legal authorities. Second, that relatively simple things can be done to promote trust and confidence in legal authorities, which in turn can lead to acceptance of decisions by authorities, compliance with decisions, compliance with the law, and even cooperation and engagement with authorities. Third, when legal authorities act in ways that are perceived as legitimate, they can actually have gains to trust, even when the outcomes that they are delivering to people are ones that we would traditionally perceive as negative. No one likes getting a speeding ticket, but you may have seen the video that was going around, the viral video with the super polite, procedurally just CHIPS officer in LA who's never, I think he finally did get one after the video came out, but had never gotten a complaint before because he made a point to treat people with dignity and respect, explain what he was doing, giving them an opportunity to tell their side of the story, and so on. And last, we have found these effects to be true even when people are involved in relatively serious offenses. In other words, these are not findings that are robust for what one might call, and you can't see me, I'm giving scare quotes, ordinary citizens, but these are findings that are robust across all kinds of people, despite the level of their involvement in the criminal justice system. So again, we think that that's a very hopeful story, that these are the kinds of things that legal authorities can do to make important changes in the operation of criminal justice processing that is good for those who are working in the system and also good for those who have to interact with it and their families.
Okay, so we're going to open things up for Q&A. But before we do that, I'd like to actually ask a question of all of you. We're going to open up a poll, and this will allow you to answer on your computer some questions about who you all are, which will just give us a little bit of information to help us make our answers to your questions as responsive as possible. So we'll give you a few minutes to do that. Okay, so we're going to give you all a few more minutes. It looks like the answers are still coming in. We have a large category of other, so some of you will remain a mystery. But it looks like we have quite a few probation officers. You are all our next largest category, it looks like. A lot of folks in law enforcement, folks working in the community, a really good mix, and then attorneys, juvenile court folks, so a really great mix. We're going to let the poll go on for just a few more seconds. It looks like people are still answering, and then we'll close it out so that we can get to your questions. But we're glad to see such a wonderful range of folks who were able to join us today. Okay, so thank you all for taking the time to answer the poll. I think what we learned is we have a really exciting mix of folks from a lot of different organizations and perspectives on the webinar. So we're going to move to your questions, and there are many of them, so we apologize in advance. We are not going to get to everybody's question. We are very easy people to find. Our contact information is on the Yale Law School website, so feel free to reach out to me, Megan Quattlebaum, directly if there are questions that are burning in your mind that don't get answered today. But we have one question that I'm going to, sorry, we have so many that I'm scrolling through. So one of you asked, quote, are we clearly distinguishing normative conduct, something that's normal for adolescent development, and delinquent action when we're talking about approaches and expectations with troubled youth? So we're going to take that one first, and Tom Tyler will answer.
So I think this is a really good question to ask. You might just ask, as a general question, what's the normal course of life for a developing child? And what we know is that many adolescents, even if they're going to be the 95% of adolescents that grow up to be law-abiding adults, do things as adolescents that reflect the lack of good judgment, the lack of emotional control. And we know that, as I said, for almost all of those young people, if they are just left alone, they mature out of crime, basically. But that doesn't mean that there's not anything we can do. And in fact, what we know from research on basically 3 spheres of development, family, school, and juvenile justice, is that every one of those stages provides an opportunity to build up respect for authority, respect for rules. So we know that if parents raise their children in ways that reflect procedural justice, that those children are more likely to develop values of following rules, accepting rules, consenting to rules. We know that in schools, if teachers teach through fair procedures, they're more likely to build up respect for school rules. And we know that if people experience procedural fairness when they deal with the police and courts, as we've already said, that builds up trust in law, support for the law, the legitimacy of the law, and leads to less likelihood of criminal behavior. So there's actually a connection between all of those. So we know that the way parents raise their children affects what the children do in school, like bullying behavior. We know that what happens in school affects whether people then become adolescent offenders and adult offenders. But at each stage, we see basically the same processes are involved in normative development. If young people experience fairness in the exercise of authority, they develop consent for authority and for rules. They're less likely to be bullies. They're less likely to be disruptive in school. They're less likely to be adolescent gang members. They're less likely to be involved in violence, and then they're less likely to be adult offenders. So there is a whole normative model here that goes from stage to stage to stage, and it turns out that by the time adolescents get to the juvenile justice system, they've already experienced a lot about rules and authority and developed a sense of either a consensual deference, trust, legitimacy, or not.
Okay, thank you, Tom. So we have another question. Someone asked, and this I'm quoting, why do law enforcement and/or the courts have to change procedures that have been working fine for decades? We need to start addressing the issue of juveniles and adults taking responsibility for their actions. So for that one, I will turn it over to Tracy Mears.
Okay. I think actually that's a really good question to take on in light of a bunch of the issues that this country has been experiencing in the last couple of years, and it was actually one that those of us who sat on the President's Task Force in 21st Century Policing dealt with forthrightly. I think the data shows pretty clearly that there are very differing opinions about whether the criminal justice system and or the courts have been working fine for decades. I think there is quite a lot of varied opinion on that. But even apart from that, there is important research that sort of, in a context in which we think it's working fine, one could have serious questions. So, for example, when Tom Tyler testified before the President's Task Force on 21st Century Policing, he noted that even though crime has fallen precipitously over the last 30 to 40 years, which we think is due, at least in part, certainly not entirely because of, but certainly in part because of efforts of police that police have made in the last few decades, that levels of public trust and confidence, even among groups that hold very high levels of trust and confidence in police, have remained flat over the last 30 years. Now, if one thought that levels of confidence, trust in police was impacted by the extent to which they were just doing a good job on crime reduction, you should be very surprised by the finding that Dr. Tyler pointed out to the President's task force. It suggests that something is going on and perhaps that things aren't just working fine. And so I think the research that we presented today gives us some insight on that and a clue about that. And I think the important thing is that even if things weren't as really not fine as it is in certain areas, in certain aspects of the system, the research that we presented today shows how the system in every aspect of it can be made better, and that the ideas of procedural justice are things that legal authorities can commit to enhance trust, make things better, to encourage voluntary compliance in a way that's really good for everyone.
Okay, thank you, Tracy. So we have another question. Someone asked, I wonder how many law enforcement trainers are aware of this research and using it in their training. For that one, I will turn it over to Tom Tyler.
As you know, training is very localized, and there's 15,500 police departments in America, so there's vast variation in, who's training whom and, what their background is. But I think what we've seen in the last 5 years is that there's been a big shift towards trainers being aware of and trying to incorporate these ideas into their training. We can give a whole set of examples. The national initiative that we're involved in has 6 different cities all over the country. And what we've done as a part of that is to create training programs and make them available. We worked with the Chicago Police Department Training Academy, which has been very involved in building training curriculum and developed basically a two-day training program. We know that over 90 police departments have gone to Chicago and worked with their trainers to learn about this training. Recently, several states, state of Washington, state of California, have approached this on a statewide level. Several major cities, we mentioned Chicago, but also New York City, are incorporating these ideas into their training program. So it seems as if there's a much greater awareness of these ideas now and a much greater level of interest because, as Tracy said, departments have recognized that even though they've had success in dampening crime, that success has not promoted trust and confidence. So the question of legitimacy is a separate issue to be addressed in training, distinct from crime control strategies. As departments are recognizing this, they're bringing this training in.
Also, there was recently, actually I think just yesterday, an article by Tina Rosenberg in the New York Times, the section called The Fix, describing some of the training programs across the country.
Okay, so we have another question. I think we have time for 1 or 2 more. This one speaks to whether the procedural justice research demonstrates that those who just see things happening to other people, perhaps see other people get arrested or go to prison or participate in a court procedure, what effect those experiences have on them, even if they may not have had experiences with the justice system themselves. So for that one, I will turn it to Tracy Mears.
Yeah, I think maybe Tom and I can speak to both of those. But I think what's interesting is it much depends on which research you're looking at. So, the research that we presented in some cases was referring to specific interactions that people were having with authorities and their evaluations of them. But some of the other research just asks individuals what they think about, people who would fit in certain categories of legal authorities. And of course, it turns out that many people, most people actually don't have any interactions with those legal authorities. And so what they learn about legal authorities, they learn from people who do, or things that they see on television, or in particular social media, for example. So if one has an interaction with a police officer, their perceptions of that interaction can in fact be influenced by the video that they watched about police officers in some other city, that they don't know. I mean, we're pretty clear that that's true. And we also do surveys that ask people about the interactions that their friends and that their family members have had in particular. So we have strong reason to think that these findings that we're talking about are the same for people who actually have interactions and even for people who don't.
Just to use a simple example of what Tracy's saying, if you look at the study that I mentioned of young men in New York, issues. One is what happened to you, and the other is based upon your friends and your family and so on. What are the police generally doing in your neighborhood? And it turned out that both of those things affected trust in the police, willingness to cooperate with the police. Interestingly, what people thought was happening in their neighborhood, so what was happening to their friends, to their neighbors, was more important than what was happening to them personally. So even though both things mattered, clearly what people thought the police were doing in general was separate and even more important. Obviously, as Tracy mentioned, we all know that the media and social media is having a big effect of communicating information even far beyond neighborhoods. And that's clearly an issue for the future, but we definitely know that that matters.
So there was a quick question about the research on police and the impact on these procedural justice trainings on enhancing trust. I just want to say really briefly that that is one of the points of the national initiative's work, is to evaluate that. And the second point is, although the research on procedural justice has been around for decades, the extension of this work into the policing arena is relatively new. So most of the research in this area has come out in the last few years, and there is ongoing really important research that people should stay tuned for. And the person I would have you look to for the sort of latest and greatest is Wes Scogan has two important studies, one that literally came out last week. And is your study with Phil out yet?
Yes.
And then Tom Tyler has a study with Phil Goff, and I think Rick Trinkner is also a co-author on that study. So, we have reason to think that obviously have reason to think that the research is clearly applicable, but the actual impact evaluations are happening right now as we speak.
And just because some of that didn't come through on closed captioning, I'll just say that Wes Scogan is Skogan, and that's one paper that came out last week. And Tom Tyler has a new study with Phil Goff, Goff. So that's all we have time for at the moment. You all had wonderful questions, and we're sorry that we can't get to them all, but we very much appreciate you taking the time to join us today. And we'll just send it back to OJJDP to close us out. Thank you so much.
Thank you, Megan. I'd also like to thank our presenters for a great discussion on such a timely topic. We have just a few reminders. This webinar will be archived in OJJDP's online university in approximately 3 weeks. For more information, contact OJJDP NTTAC or John Jay. To speak with a diagnostic specialist about how the Diagnostic Center can help your community address a criminal justice or juvenile justice or victim service problem, please find the contact information on this slide. The National Initiative for Building Community Trust and Justice is supported by the following branches of the U.S. Department of Justice. And lastly, please take 5 minutes to complete the feedback survey. Thank you again for joining us today. Have a great afternoon.